Hi there, everyone. Welcome to the first in our fall series of webinars that are coming up. Thanks so much for joining us on this beautiful Wednesday. I'm going to give everyone a minute or two to join and go over a few housekeeping items while we are waiting. This is going to be a really great webinar with Christine Brown Murphy, sort of her personal story. An estate planning and elder law attorney who actually, we advise people on this all the time, but, she went through it with her own family. So I think it's a really great story to share. So as I said, let's talk a little bit about some housekeeping items. If you have any questions throughout the presentation, you can type them into the Q&A box that you will see on the bottom, and we will do our best to address those as they come up. And just in the interest of time, I think I'll have us get underway. So I will introduce Christine. And again, welcome to everybody. Christine?
Okay.
Oh,
Sorry. Hi, everyone. Thanks for joining us. Surprisingly, I do lots and lots of webinars, but this one was particularly difficult for me to put together. Just kind of, wanting to balance sharing information and sharing my family's perspective, but also respecting, the privacy of my family, and just the journey. It's deeply personal. But what I'm going to do today is really just talk about my parents' circumstances. After 57 years of marriage, my mom ultimately making the very difficult decision that my father had to be placed in a nursing facility, where he still is to this day. And so I think it's important for us to discuss the truly profound challenges of having to make that difficult decision. So it's a very, very personal story that we're going to embark on here. Okay, so these are my parents. They are super awesome, really loving folks. Had 5 kids, and we all get along pretty well. So maybe we're unique in that sense, since I do get to deal with family stories on a daily basis, living and learning through other families' experiences, really how to implement a lot of what I hear on a daily basis into how I choose to raise my own children and live my life. But these are my parents. They've been married for actually 58 years now. They were homeowners and what I would say be modest financial means, right? Kind of worked hard all of their lives, had their home that they paid off, put a little bit of money in the bank, but they had 5 kids. My dad was a steel worker. My mom was an immigrant who came from Egypt at the age of 20 years old, and really lived the American dream. This was the greatest country in the world to her. And she met my father, got married, they had 5 kids, and now they have 13 grandchildren. And, things happen as we age. And that's exactly what happened with my family situation. So I'm going to walk you through how I handled the dementia diagnosis and what I knew to be a trigger for us to begin to get some things in place. So what I think is very, very important to understand is I obviously have a very unique understanding and set of skills and knowledge that most families don't have the luxury, unfortunately, of having as part of their family arsenal. Okay. And so what I want to do is really explain to to all of you the difference between what an elder law attorney is and what an estate planning attorney is. And so you are clear, I do both. I am both an estate planning attorney as well as an elder law attorney. But what I bring to the table as far as estate planning goes is the knowledge that you cannot ignore the possibility of long-term care. So as an elder law attorney, my focus is on the legal and financial needs of older adults, just like my parents, right? The circumstances we knew with my dad's dementia diagnosis, they were going to begin to face. I specialize, and our firm specializes and focuses their practice on Medicaid planning. So for a lot of people, when they hear Medicaid, they automatically think Medicaid's off the table. We have assets. There's no way we can be eligible for Medicaid. And what this story is going to teach you is that I utilized all of these public benefits for the absolute benefit of my parents and still do to this day. So we do long-term care veterans benefits planning, and we help families navigate nursing home admissions. My primary goal when helping families, and our primary goal as Zachariah Brown, is to preserve hard-earned assets during your lifetime, especially when facing a dementia diagnosis, which, like my mother had to face in 2021 with respect to my father's diagnosis. While all elder law attorneys practice estate planning, most estate planning attorneys do not practice elder law. And that means that if you have an estate plan that was simply done by an estate planning attorney with no knowledge of how important it is to plan for long-term care, it's time for you to revisit your estate planning documents. So an estate planning attorney, on the other hand, our primary focus when we're talking about estate planning is how can we make sure we pass assets on as efficiently and with least taxes as possible upon our death. We focus on preparing documents like wills, trusts, powers of attorney, etc. We help to make sure we can maximize tax planning by minimizing expenses against the estate when someone passes on. And we are looking to make sure we can preserve the legacy for the next generation. As an elder law attorney, we're looking to preserve your legacy for your very own, for yourself and that of your spouse. All right, so the reality of what long-term care costs is, my parents had, again, somewhat modest means, right? They owned a house and they had about $350,000 in total countable assets. And so we knew that there was going to be some risk at that time. Now, for most of us dealing with a long-term care need, this is the reality. An estimated 69% of individuals reaching 65 or older will need some assistance with activities of daily living. The average stay in an assisted living facility is about 29 months. And if the average cost of that is $6,000 a month, you're looking at just $174,000 just for those 29 months. 59% of those folks will end up in a nursing home. And did you know that the average cost of nursing home care in Pennsylvania is $12,160 per month? It's tremendously expensive. So we're talking about if any one of us follows this trajectory of need, that we are looking at an astounding $721,000, my parents' nest egg and beyond. And so I knew, obviously, very important for us to begin the process of looking at their estate documents, making sure things are solidified to ensure that my mother, who was the healthy spouse, did not become impoverished. We also know for many of us listening in today that the average income lost by caregivers, right? So my mom is the caregiver. Now she was retired, so this number didn't impact her. But if my siblings or I had to leave the workplace or had to give up time in our workplace, the average caregiver loses about 33% of income by being an at-home caregiver for a loved one. And they also pay out at least $10,000 per year out of their own pocket for caregiver needs. Now, I'm fortunate enough. I have 5 siblings. My parents all emphasized education to be tremendously important careers. And so we were able, obviously, to assist my parents when some of the decisions for care needed to be made. But many families are not in those circumstances, and many parents don't want to accept that financial help from their own children. The real reality here is that for women leaving jobs, right, because most women end up being the ones who have to leave their job to provide for a loved one. That results in really compounding that loss by lost wages, pensions, Social Security. And that can result in the statistic is it results in over $300,000 of lost earning power because someone has to leave the workforce to provide care. So when my dad was diagnosed with dementia, obviously, me being an elder law attorney and an estate planning attorney, I had my parents' documents, well in place. They had their elder-focused estate plan in place. But the reality is we had to face the painful reality that when we prepared these documents, both of my parents were healthy. And so while my dad had all of the very necessary durable powers of attorney, durable healthcare powers of attorney, we knew my mom's documents were going to have to be revised, right? So we wanted to update my mom's financial powers of attorney, update her healthcare powers of attorney, and also adjust beneficiary designations. The reality is oftentimes when we do a lot of this planning, we assume the spouse who is healthy is going to be the one who outlives the spouse who is not. And so when we're approaching these types of issues within families, we know that not only are we going to deal with and do we have to face the reality of this individual being sick and likely needing very expensive care, we can't ignore the possibility of all of this planning that we do could be undone because the spouse who is healthy now passes away first. So when my dad was diagnosed with dementia, we knew we had to go in, remove my dad as the acting agent under power of attorney for mom. Because if something happens to mom, we need to make sure we had the proper people in place to manage mom's finances, make healthcare decisions for her. I'm fortunate enough to have, a couple of sisters who are doctors, so we knew who was going to be the healthcare decision maker. I became mom's financial power of attorney, and we knew that with respect to assets that my mom was going to be able to keep as we began to move forward to Medicaid eligibility, that we needed to remove dad as the beneficiary of any of these assets. Okay, the idea again is if mom passes away, dad would not be able to live at home in the community on his own, and we would need to place him and have him become eligible for Medicaid. And if mom passes away and leaves all of these assets to dad, we now have risk associated with all of these assets that he now owns. Okay, so let's talk about what we did with mom's will. We created mom a community, I created mom a community spouse will, which means prior to my dad's diagnosis, their wills were typical sweetheart wills. Okay, and what does that mean? That means that when dad passes, everything goes to mom. When mom passes, everything goes to dad. But again, in what I do on a daily basis, I realize that the goal again is that we're working toward dad becoming eligible for Medicaid or potentially needing to become eligible for Medicaid to pay for in-home care or nursing home care. And so we want to make sure that when we employ these strategies, that all of these steps that we're taking do not become undone in case mom passes away. So what did mom's will say? When we updated mom's will, talked with mom, and we had to have kind of a real frank discussion. The reality is, mom, how do we want this will to be worded? Do we want the will to say that if you pass away first, that all of the assets pass to your children? Or do you want the will to say that if you pass away first, that your will have a special kind of trust built into it for dad? And that special kind of trust is actually called a special needs trust. Okay, and this is what we did with mom's will. We created in mom's will, it said if she dies first, a portion of her estate goes into this special needs trust for the benefit of my father. Anything he needs is provided for him out of this trust. But if my dad is on Medicaid or becomes eligible for Medicaid in the future, that trust shuts off and the assets in that trust stay within the trust, and Medicaid in the nursing home can have no access to the assets within that trust. Okay, so that's what we did. We updated mom's will and said, instead of these assets passing directly to my dad, or instead of these assets passing down to her children, we directed the assets into a special needs trust to protect those assets in the event mom passed away first, and to ensure my dad could either maintain Medicaid eligibility upon her passing or become eligible for Medicaid in the future without those assets being exposed. Okay, so why I have to emphasize and why I have another slide here regarding powers of attorney is because they are by far the most important documents you can have. Okay, and I will tell you right now, they are not all created the same. You need to have elder focused powers of attorney as we begin to, hit retirement age and move along the aging continuum, because there is a fundamental difference in these documents versus other legal documents. Okay. There's a lot of steps that we have to make sure when we are looking to protect assets from long-term care exposure. We need to make sure the language is in these documents, some of which is creating an irrevocable trust, which I did not have to do for my parents, but I will talk about it because it may be something that's appropriate for you. So not a revocable trust, but an irrevocable trust. We need to make sure that the language in your documents allows you to change beneficiaries. So my mother had a retirement account, an IRA, and on that IRA or 401k, my dad was listed as the beneficiary. And we had to sign off on allowing my mother to remove my father as beneficiary. Now, my dad no longer has capacity. So at the time that that change was made, it had to be signed by power of attorney. So because my mom had powers of attorney that I created, of course, it had that protective language in it. It allowed her to remove my father as beneficiary of her IRA. But I have absolutely run into this problem in the past with some of my clients. That if the language in the power of attorney doesn't allow your agent to remove you as the power, or I'm sorry, as the beneficiary of an investment, we could be stuck. And if mom passes away and dad is still the listed beneficiary on this IRA, there goes that money. Dad gets it, he's off of Medicaid and now has to be used for long-term care. Powers of attorney are tremendously, tremendously important. Do not take it for granted that you can download one off the internet or buy one at the store. They are the most fundamental foundation of estate planning that any one of us can have. Okay, I live in a community with a lot of, great families. I have a lot of kids going off to college. What do you think happens every summer before kids go off to college? Parents are calling me to say, I need power of attorney for my children, right? Because once you hit 18 years of age, you're an adult. And so we need to make sure mom and dad have that proper legal authority to make decisions. Okay, so just how it goes along the gamut, how it goes along the continuum of life, that these are fundamental, very, very important documents. And I want to point something out too. There's no automatic right that my mom has the ability to access my dad's assets or sign anything off on his behalf. Without a power of attorney, many of the assets could be exposed because as spouses, you don't have any automatic right to act on behalf of your other spouse. So with respect to medical decisions, right, we wanted to make sure that with the power of attorney we had, it was able to provide my mother with peace of mind. She has access to all of my dad's information, can make all of those important decisions. And in fact, I can with her as well because she has signed off and giving us access, my siblings and I, access to information. There was a definite precarious time with my father's condition. He was not that happy-go-lucky dementia patient. He was always been a fighter, always been a tough guy, smart, hardworking, and just tremendously brilliant. And so when he began to lose his cognition and was aware of it, it was not easy. And there were definite times where my siblings and I and my mom were having, Zoom meetings with his PCP to figure out what medications to calm him and to make him less paranoid. It was a very, very significant struggle. And without those documents in place, none of us would have been able to have that access or those conversations. So very important to make sure you have these documents. What happens if we didn't have these, right? So if we don't have our healthcare powers of attorney, our living wills, our durable powers of attorney, my mom would have been stuck going through a guardianship proceeding. Now, again, she has the somewhat luxury of me being an elder law attorney to be able to do these things for her. But the reality is if somebody becomes incapacitated without these tremendously important documents, we're now going through a guardianship, which is going to cost families somewhere between $3,000 and $15,000. So it's tremendously important to make sure that these steps are taken before you begin to deal with these significant crises, okay? So I didn't do an asset protection trust for my parents, but it's such an important thing to discuss that I do want to have this conversation with you. So it could be part of your estate planning arsenal, okay, of planning, and oftentimes it is. So when clients come to me and there's no diagnosis, but they're hitting that 68, 69, 70 years of age, they start having concerns about long-term care exposure and they're wanting to pre-plan. And this is often a tool that we want to utilize or consider, okay, when looking to do asset protection. An irrevocable trust allows us to identify certain assets and transfer them to the ownership of the irrevocable trust. Now, Medicaid has a 5-year look back. They want to know, what have you done with your assets 5 years prior to applying for Medicaid? So if you have the luxury of pre-planning and your assets are at a threshold that it makes sense for you to do this kind of trust, we want to think about it in advance, typically. Now, there are many scenarios where we utilize irrevocable trust while somebody is actually in a nursing home and we need to implement a plan to protect assets. So in essence, it's never too late. But an irrevocable trust is a smart way to plan for the protection of assets. Oftentimes, families want to just go ahead and begin divesting their assets and giving their assets to children. And that is almost never a financially smart plan. You typically end up creating very significant and heavy tax consequences for your children, which is not fair to them. The trust costs a fraction of what those subsequent tax consequences you've created for your children will create. And if you have done this trust 5 years in advance, all of the assets that you've transferred to the trust ownership are completely protected. Okay, so it's very important to understand that this is a very, very smart strategy for folks who want to think about planning in advance and who have a certain type of assets and a certain kind of nest egg, and particularly for single individuals, that you're going to want to utilize or consider. It's not a revocable trust. A revocable trust does nothing to protect your assets. So you'll want to utilize an irrevocable trust. So when Dad's condition began to, again, as I said, he was kind of that really stubborn, difficult dementia patient, okay? Super loving guy, great grandfather. My children, have the best relationship with my dad. But the reality is he began to get paranoid. Because he knew something was wrong, right? He was losing his faculties. And so my mom, it was becoming very, very difficult for my mother. And so we were looking for options. How can we give my mom some reprieve and get my dad out socialized, okay? And so we looked at Prime Time, which frankly, Primetime's a fantastic program. Basically, it's an adult daycare, and it costs about $60 a day. And they do all kinds of activities with those individuals. They can feed you lunch. They do all kinds of art activities, and just trying to keep individuals engaged. Well, it was about $60 a day, so it wasn't tremendously expensive. There's no Medicaid for this type of plan, but it was. My dad would go into the program. And he just kept saying, he's like, all those people are old in there, right? He wasn't comfortable going to the facility. And so it was a very short-lived fit, at least for my father. I know plenty of clients have utilized Prime Time, and it has been a great option for them. But for us, it's just, again, it taught us again that what we knew is that not all dementia care solutions work for every individual. And so it's continuing to work through these different hurdles and programs to decide what program is going to work best for Dad. Because again, Mom was really beginning to have difficulty. The reality is, we would get phone calls at 10 o'clock at night, and there were significant issues, and one of us had to leave our homes and go and try and settle things down at home because he was very paranoid. Oftentimes didn't recognize my own mother in the house. And so those were things that were very, very difficult as a family overall, to deal with, and particularly my mother. He would call endlessly, explaining that there's someone in the house and you didn't know who they were. And, these are just challenges that I know so many families deal with because I hear it on a day-to-day basis. And so we can do all the planning we want from a financial and legal perspective, but there's still an insurmountable, difficult, emotional trauma and balance that you have to find to be able to get through these times. So I can't imagine what it's like for families who have done no planning. So after we realized that prime time was not going to be the solution for now, this is when we began our Medicaid journey. And this is when I realized, okay, we need to start this process. We need to begin to get some home care where my dad is the most comfortable in his home that he's been in for 57 years. And so we knew we needed to get the home care process started. And this is when I began to employ all of the strategies that I employ for my very own clients. Okay. Now, this Medicaid waiver program, what it is it is a program that allows you, it's for individuals who are otherwise medically eligible to be living in a nursing home, but the state will actually pay for care to come into the home. A home care agency, you get to choose. And in fact, Medicaid will also pay for a family member to provide this level of care. Okay. So if I didn't work and I wanted to be this caregiver for my father, I could apply through this program and be compensated to be a caregiver for my father. That's not the path we took. We just went straight through the Medicaid waiver program where we picked a home care agency. But I know the duration and how long it takes for us to get these programs in place. At the time we applied, my father was still walking, bathing on his own. My mother had to consistently, assist him with getting dressed. He couldn't be left alone by any means. But because of his advanced dementia diagnosis, I knew that this condition was only going to continue to deteriorate. The waiver program takes a long time to actually become eligible for because the system is so incredibly broken right now, meaning that the application process itself takes months and months and months to get. So with that knowledge, I knew let's just be proactive. Let's get dad into this waiver program. Let's get the process started. So to be eligible for this program, financial eligibility as far as assets go are the exact same criteria as if my dad were going into a nursing home. The income is the only distinction between these two programs. The income for the individual applying for this program cannot exceed $2,901 per month. Sometimes that number can go all the way up to $3,401. Okay, now that's not my parents' income combined. That is my father's income only, Social Security and pension for my father. He met that criteria. His income met that level. Now, for him to be eligible, he will only be permitted to have $8,000 in total in his name, okay, of countable assets. And so, of course, I knew all of these things, so I began to employ our strategy. But for all of you, what's important for you to understand is what does Medicaid consider to be countable versus non-countable, okay? So non-countable assets, my parents' primary residence, non-countable. The one vehicle, which they only had one vehicle, which that was actually the biggest point of contention. Every time there would be a fight, it's because my dad wanted his keys. He wanted to drive somewhere. But one vehicle, their personal effects. If they had a business, meaning if they had rental property or an income producing business, that would have been exempt. The community spouse, the healthy spouse's IRA or 401k is also exempt. Prepaid funerals, exempt, and a very small amount of life insurance. Everything else is considered to be a countable asset. Okay, regardless of what you may have heard. We get people coming in where they say the nursing home told them that only his assets need spent down. No, all assets are countable unless they fall into the non-countable asset pile. So what did we do? When we knew prime time was no longer the solution, now I knew their asset vulnerability existed. So this is what their situation looked like. $350,000 in total countable resources. My mom had about $180,000 in an IRA, and their family home was valued at about $220,000. So what do we know from that prior slide? We know the IRA is exempt, and we know the family home is exempt. What did I do? I immediately removed my father's name from the deed, right? Now my mom owns that home, and mom's new will would control that house if something happened to her, right? So now that will doesn't direct everything back to my mom, but instead directs it into that special needs trust in case she would pass away first. We changed the beneficiary on my mom's IRA to her children. And we identified what mom gets to keep And then we made plans to preserve the rest of her assets. And this is how we do it. And this is what it looks like, right? So what Medicaid says is of the countable assets, my mom will get to keep $157,920. My father will get to keep $8,000. So the remaining spend down is how this will work. So if we have $184,000 that's left for spend down, a lot of people think, and what nursing homes will tell you, is that is that you have to pay that nursing, you just have to spend the money until he would otherwise be eligible. Or if they're in a nursing home, they'd say, spend it on the nursing home. That is never what we do. Never. What we do first is identify certain things that you actually do need to spend money down on. Do you have any credit card bills, a home equity loan, a mortgage? Do we need to pre-plan funerals? Do you need to hire a lawyer to facilitate this process? Keep in mind, hiring a lawyer means that this is money that would otherwise go toward the cost of nursing home care. Hiring a lawyer, in a sense, doesn't cost you anything because we are ultimately protecting these assets for you. That would just be money that otherwise goes towards your cost of care. So this is what we did, right? So we decided to purchase what I call as a Medicaid compliant annuity. Now, of course, again, I'm an elder law attorney. I do this every day. So I completely understood what we needed to do to protect these assets for my mom. So again, mom was able to keep $157,920. She was able to keep the home that we now had just titled in her name alone with her updated last will and testament. My mother was able to keep her IRA with updated beneficiary designations. And my dad was able to keep $8,000. Now, my mom's name absolutely will be on that $8,000 with him. It will not be, and she has complete use and access to that money as she needs. So I took the remaining money and we purchased what we call a Medicaid compliant annuity. Medicaid actually permits us to take this money and convert it for the benefit of the healthy spouse. Okay. Ultimately, and the next slide will explain to you how this annuity works, but essentially, Medicaid says that the income of the spouse who is not in the nursing home is completely exempt, non-countable. The income of the community spouse is their income, and their income has no impact on their spouse's eligibility. So we took that asset, that $184,000 that would have otherwise had to have been spent down, and we bought this annuity for the benefit of my mom. This annuity was structured to pay out completely to my mother within 12 months. So for 12 months, she received $15,340 per month. At the end of that 12 months, she has completely reaccumulated that $184,000 in an account that does not have my father's name on it. Just so you know, that money went into an account that was in my mom's name alone, with actually my brother's name, because we wanted to make sure there was someone on the account with my mom in this circumstance. And that money has just now reaccumulated back into her account. And dad became eligible for in-home care for waiver. Okay. Now, what is this Medicaid compliant annuity? It basically converts otherwise what we are considered to be assets that makes someone ineligible for Medicaid into a stream of income for the spouse who's not in the nursing home. And just so you understand, these strategies in Medicaid compliant annuity also works for a single individual as well. All right. It's just, we employ it a little differently, but there's never a situation where we cannot protect assets, whether it be for a married couple or a single individual. Okay. So here again is just a little summary of what this Medicaid compliant annuity is. So this strategy allows us to convert assets that are otherwise countable into a stream of income for my mom. It allows her to completely recover the money. It protects her income, and please don't go out and anybody buy an annuity right now, because it will not be the right kind of annuity. This is only the type of annuity that we utilize when we are looking to become immediately eligible for Medicaid. So by this planning, we have now been able to devise an effective plan to get my dad the care he needs at home and protect all of these assets for the benefit of my mother. So this picture here is a picture of my mom and dad, and this was the day before my dad actually had to move into a nursing home. He looks pretty good, huh? He does look pretty good. but it just had gotten to the point where he absolutely could not be at home anymore. It was becoming dangerous for my mother and for himself. And so we went out for a little cruise in the convertible, just really probably more so for my mom and myself rather than for him, but just to be together as a family. And so, unfortunately, after just 1 month of him being on this waiver program, my father's situation deteriorated where he had to go into a nursing home. Now, what I can tell you is that all of this planning that we did in advance and just being very proactive and how we approached his care, it became where when my dad went into a nursing home, it was like just flipping a switch. He went into the nursing home and he was already eligible for Medicaid. We had to provide just some income information to the county assistance office in the nursing home. Ultimately, he's paying only $200 a month for his care in a nursing home, and he's doing actually remarkably well. My mom's a pretty awesome mom, so she's there every day, of course, making sure he's well taken care of. My siblings and I try to transition through once a week so we can all pop our head in there and see dad. Every once in a while, we do get to take him out, maybe for a Sunday lunch or brunch. It's getting more and more difficult. His mobility has really, really declined. But he's doing well. It's probably more difficult for my mom and I and my siblings that he's in a nursing home than it is so for him. But I will tell you now that all of this proactive planning has given my mother mostly, and us, because we're her children and we love her and want her to be well taken care of, and my dad has provided them significant peace of mind. We've never had to worry about my mom's nest egg being at risk. So if only of us could look this sophisticated as an aging individual, but basically, losing their home, and it says 40 years, is actually 57 years. So these were some of the concerns that most people would face: is what happens if I lose my home? No parent wants to become a burden financially to their children. And so that was a concern of moms and for many of you as well. And just obviously navigating, because I'm telling you, Medicaid's complex. I mean, it's tremendously complex. Don't ever think it's just going to be an exercise of document gathering. It's not. I've been doing this for 23 years. Medicaid has become exceptionally complex and difficult. And if you don't have professional legal guidance assisting you through the process, I don't know how you get through it. But obviously, knowing that we had the planning done provided significant peace of mind to my mom. It allowed her to be able to make all of the decisions necessary for my father. It allowed us to all be, involved in his care. But this is basically my family. Their family and their children and grandchildren are absolutely the most important thing to them. Pretty sad that, unfortunately later in life that this is what happens. But unfortunately, it's a reality, and pretending it doesn't exist and not facing this reality only puts you in a bad place financially and emotionally. And so just with the support of my siblings, and obviously with my knowledge as being an elder law and estate planning attorney, dad's doing well, and my mom has absolute peace of mind that she financially will be okay. And so this is the family. I look at all these pictures and I could just laugh seeing how, everybody's changed and grown up and all that good stuff. And so this is our team. I had to plug in Melanie Lewis as our newest attorney, so her picture is not quite as perfect looking as some of the rest, but this is our team, and we take great pride in what we do and how we help families. And if you or someone is facing a long-term care need, or is dealing with a dementia diagnosis or Parkinson's or anything that we know is progressive, or simply just aging and mobility is becoming more difficult, don't ignore that you have to be proactive. Things don't just work their way out. You have to have the right planning in place. All right, do we have any questions?
Unbelievably, we do not, although I think because your story was so amazing, and people were just listening to it. Thank you so much for sharing that. Oh, look, now we're getting some questions.
Okay.
I don't know if you can see them or if you want me to read them to you, Christine.
Well, I don't want to share the names, so if you could read them to me, that'd be great.
Yes. Well, most of them say anonymous.
Oh, okay.
To create an irrevocable trust for someone from my traditional or Roth IRA, do the assets, treasury bonds, need to be sold, liquidated first, or can the bonds be transferred to the irrevocable trust without selling them?
Good
Yes.
question. Irrevocable trusts, retirement accounts, any kind of IRA, 401k, qualified retirement plan cannot be owned by anything or anyone else other than an individual. So if you have a retirement account, we cannot put those assets into an irrevocable trust. If you have bonds that are in your name or in your name, but they're not retirement affiliated, yes, we can retitle those to an irrevocable trust for asset protection. And if you have a Roth IRA, I mean, these are discussions, points of discussion, I should say. You know, if we have a true concern about asset protection and maybe you're single, Roth IRAs don't have any tax consequence if we want to consider liquidating them to fund an irrevocable trust. But again, that would be part of a conversation, a bigger conversation. We would have a broader conversation. But retirement accounts cannot go into an irrevocable trust. Non-retirement accounts, non-retirement assets can.
Okay. Thank you.
You're welcome.
Right now, we don't have any other questions. I'm just going to leave it open for a moment. And I'm also going to talk about, we have an event coming up at the end of September. It's on Friday, September 26th. It's called Learn, Care, Share. This is our fourth annual year of doing it. It's a free event. We bring together about 20 vendors. We have a great lineup of speakers to sort of talk about not only the legal ramifications of, if you have an aging parent or loved one and what you want to think about for protecting assets, but it's really also focusing a lot on the person caring for someone, either a parent or loved one, and all of the different benefits that may be available, the supports and services. So the morning's sort of laid out where you can come and visit with the vendors first thing in the morning, and then we have different speakers speaking anywhere. We have 5 of them from 10 to 15 minutes, and then we have an open panel discussion where you can ask questions. It's a really great morning. We have chair massages. We have other opportunities for self-care for the caregivers who are coming out. But we always get tremendous feedback. So if you go onto our website, which is zacbrownlaw.com, and it's zacbrownlaw.com. All of our upcoming events are there. We have a couple other webinars coming up, but that's our big in-person event at the Loft Conference Center at South Point. So hopefully you, or if you have friends that can benefit from hearing about this type of stuff, it would be a great opportunity, free opportunity to come out. Okay, here's another question.
Oh, okay.
Did your mom have to pay taxes on the monthly income from the Medicaid compliant annuity?
Great question. And
Very
no, she
good
didn't.
question.
Yeah, no, she did not. And the reason is because the way we structure this annuity, it's truly a return of principal. So because it's structured to pay out so quickly, because we want mom to reaccumulate all of those assets back into her name rather than keeping them stuck in this annuity, that no, she did not, because it's not income, it's a return of principal. Medicaid classifies it Medicaid classifies it as income, but it really truly, from an IRS tax perspective, it is not. Great question though.
Yeah, that is a great question. Um, I don't see any other.
Okay. Well,
Oh,
everyone,
wait,
thank you
someone
so much.
raised their hand here. Let me
Oh,
see. Are you able to type a question into the Q&A for us?
can you?
Yeah, I'm gonna see. I can unmute you if you would like to ask a question that way.
He's gonna,
Um,
he'll have to unmute himself.
yeah, you will have to unmute yourself. Or you can type it into the Q&A. Okay, well, you can always follow up if you want with us. There is a form on our website. Also, you can always submit questions, or if you'd like to set up a consultation or get more information, there's a place where you can reach out to us there. Thank you so much to everybody. Thank you to you, Christine. I mean, you and I are close, so I really appreciate what it took to share that story. And I hope everybody came away. Oh, discuss the $8,000 limit for Medicaid.
Okay, yeah. So when someone becomes eligible for Medicaid, they obviously have to be of reduced financial means. And so for my father to be eligible, he was only permitted to have $8,000 total in countable assets in his name alone. Now, sometimes that number can be 2,400. But it all depends on your income. If your income exceeds on a monthly basis, your gross income, if your gross income exceeds $2,901 a month, you're only permitted to have $2,400 in your name. If your income is less than $2,901 a month, then you are permitted to have $8,000 in total countable assets.
All right.
All right. Well, folks, if you have any
Um,
other, I'm sorry, is there another question?
no, that's okay. Will this be available later for you to review with your parents? Yes, we are going to get this up on our website. We have a bunch of past webinars on there as well. Under our information hub, if you go to our website, there's great articles, videos with all this type of information. But this one, we're moving our office next week. I'll let everyone know across the street, really close. We're at 111 West McMurray now. It will be 108 West McMurray. So it may not be up for a week or two. But yes, it will definitely be on our website in the future.
All right.
All
Thank you,
right.
everyone. Have a wonderful day.
Have a great day, everybody. Thank you so, so much for joining us.